I'm Robert Shapiro. I'm the interim dean of Emory Law School, and it's my great pleasure to welcome all of you here today to this very special occasion in the life of the law school, as we're here to honor our colleague, Professor David Bederman. I'd like to extend a special welcome to David's family, to his wife, Lori, to his daughter, Annalise, and to his parents, Jolene and Sanford, who are here. I'd also like to thank so many of you who have come from near and far to be here. I know that some have come from as far as Romania and as close as down the street, and we're so pleased to have you with us here today. Now, first, I'd like to say a little bit about this occasion. David's colleagues, students, and friends decided that we wanted to honor him by endowing 3 special projects relating to interests close to his heart. One of those will be a student fellowship to allow some Emory Law students to spend a summer at The Hague, at the noted Hague Academy of International Law, following in the footsteps of David and Lori, who studied there 25 years ago. Another project is the David Bederman Professorship, to bring a distinguished scholar to Emory to continue to cultivate some of the many fields that David has so brilliantly advanced. Now, those projects are still ongoing, but a third project, the Distinguished Lectureship, has reached its culmination, and we're here to mark that today. Now, when we were thinking about who would be the absolute best person to be the inaugural Bederman Lecturer, to embody those great skills of scholarship and humane learning that will be attached forever to that lectureship, of course, there was one clear answer, and that was David Bederman. So, I'd just like to say a little bit about our distinguished lecturer. David's record of scholarly achievement is impressive to the point of improbable, actually. He's written 12 books, 125 articles, 80 public lectures, in addition to serving on scores of boards of scholarly journals and other organizations. He has taught over 4,000 students in 15 courses and taught many more colleagues across this country and across the world. David's also been active in law reform projects, litigating in courts high and low, including 5 cases in the United States Supreme Court. David's range of expertise is broad and deep. He's an expert in international law, in admiralty and legal history, in constitutional law and federal jurisdiction. And of course, these areas are reflected in his signature monographs, International Law and Antiquity, The Classical Foundations of the American Constitution, and most recently, Custom as a Source of Law, which will be part of the foundation for his lecture today. Now, his articles range across these fields and many more. Some of his other articles have been about things such as world law, the law of the Antarctic, and hate crimes against vegetables. In the New York Times, David actually analyzed President Bush's insults to broccoli. Very wide-ranging scholar indeed. Well, David's one of the most penetrating and original thinkers in all of these areas. He also has a unique ability to communicate his ideas to a broader public and to work for transformation. He's a man of ideas, but also a man of action, a man deeply connected to the world. While David is conversant in the culture of Greece and Rome, he's also quite conversant in popular culture as well. One can converse with him about Glee, about Who Wants to Be a Millionaire, and about Star Trek. Now, appropriately, when David was invested with the Gyr chair in this room 3 years ago, he chose as his topic, the Pirate Code. His characteristically erudite discourse included citations to the great classics of jurisprudence, to H.L.A. Hart and Austin, to Savigny and Grotius. But his examples also came from the Hollywood School of Jurisprudence, including Captain Jack Sparrow. And if you follow the citations, you'll find such references as C, Pirates of the Caribbean, At World's End, Supranote 28. Now, it's that grounding in the real world that makes David such an effective teacher and such an effective advocate. In the Supreme Court and in other courts, David has demonstrated his characteristic poise and common sense. For example, in his very first oral argument in the Supreme Court, David was arguing about the tort liability standards in Antarctica. It turned out that somehow the justices ran out of questions before his time ended. But David knew that there's a time to sit down. So I'd just like to read to you briefly the record of that argument as recorded in the official transcripts of the United States Supreme Court. The following colloquy occurred. Mr. Bederman, I have no further substantive points. Question, do you have any non-substantive points? Mr. Bederman, I will not rise to that invitation, Chief Justice. So, I'm very happy that David has risen to our invitation to give the inaugural David J. Bederman Lecture. Please join me in welcoming the K.H. Gyr Professor of Law, our friend and colleague, and a hero of mine, Professor David J. Bederman.
Robert, thank you so much for those very gracious and to some degree undeserved remarks. I'm glad to be here in so many respects. I look out in the audience, I see so many friends. I'm going to try to spend a few minutes with each of you after the lecture, but I am deeply touched and honored that you would spend your afternoon here, come so far to be with me today. It means a lot to me. Thank you very much. My talk today is about, or at least is entitled, Public Law and Custom. But the first thing I need to warn you about is that law professors just love puzzles. Give us a legal doctrine that doesn't make sense, or appears counterintuitive, or does not appear to comport with some methodological assumption, and we could spend months, if not years, plumbing its depths and producing reams of paper and exploring its contours. The good news for you today is that my exegesis shall be limited to the length of this lecture, which has been set at about 45 to 50 minutes. So let me first set out the character of the puzzle and see if I can't solve it in that period of time. Today's puzzle can be simply stated. Can public law be made or modified by custom? Now that sounds dry and arid, and it might be an invitation for you to leave and start snacking on the reception food that's just outside, but bear with me for a moment. And let me define some of my terms. First and most importantly, what do I mean by custom? Well, the lawyerly definition is unofficial and unenacted law, the practices and usages of a particular community. But I think the better way to approach a definition of custom is to give an example. And this is what I would call the customary law of Hal and Ruth. Many of you will know that we lost our dear colleague, Hal Berman, a few years ago, and he told me and our class, which we taught together, this story. The story runs like this. In a particular community known as the Berman family, for 65 years, when they were at home, Hal would make Sunday brunch, relieving his wife of long standing the responsibility for cooking, at least for most of Sunday. So Hal made brunch for every Sunday for 65 years. Now, based on what are known as the objective criterion of a custom, that's pretty good. In terms of a duration element, 65 years is a long time. It's a long time to be married, too. And as for consistency, making Sunday brunch every Sunday they were home is also pretty good. But Hal went on with his story and asked a very simple question. And that is, what if one Sunday morning he just didn't feel like making brunch. Or he was mad at his wife, Ruth, for probably no good reason. Was he under a legal obligation to perform, to make brunch? And so that was a nice way of asking was, had this practice, had this usage ripened into a legally enforceable custom? It's a question we kicked around for a lot of the class and in private discussions. But what Hal reminded me of in his gentle wisdom is that custom is law made from the bottom up. It's not a statute passed by a legislature. It's not a precedent handed down by a panel of judges. That's top-down law. Custom instead is made by the communities in their actual life. It's bottom up. So that would be my working definition of custom. Now, what do I mean by public law? Well, public law is the domain of legal relations dictated by the state. It stands in contrast with what we call, yes, you guessed it, private law. That's the ordering of affairs between individuals in contracts, torts, and property, the bedrock of the first-year law school curriculum. The core of public law is often viewed as administrative, criminal, and constitutional law. But the boundaries between public and private law are increasingly being blurred. Don't worry, I'm not going to say anything more about that. That's a subject for another lecture, not today's lecture. Now, the nub of my puzzle is that many prominent legal theorists have asserted that even if custom should be recognized as a source of obligation, there are limits to its domain, and one of these is that customary norms cannot remake public law, that custom has no effect on public law. Scholars like James Coolidge Carter and T.F.T. Plucknett, I love these names from the pantheon of legal scholarship. I won't say more about these individuals, regrettably I don't have time to. Plucknett's assertion, I will say, was made part of his great survey of the English common law. Carter's discussion was in relation to what he viewed as an ideal legal system. So the notion that custom can have no effect on public law rules has been stated both as a matter of description in legal history and also as a preferred norm in the design of legal systems. And who am I, a lowly professor here, to doubt the views of these great thinkers in legal theory? So you need to keep in mind that there are many skeptics of custom as a source of law, but within this group, most are adamant that public law is just too important to be influenced by customary law-making processes. Now, I'm going to put one other constraint on my talk today, and that is I am not, repeat, not going to talk about international law. Now, that seems strange because that's the area that I teach mostly in, that I do most of my writing in, and where it is fairly well established that custom can change the rules of public law. So I'm going to make my task a little harder today by not talking about international law at all. That'd be kind of like shooting fish in a barrel, just not fair. I also think that lectures like this ought to have some creative tension. You should be worried on my behalf as to whether I could really be held to my proof and make my case in 45 minutes. Doubt me and let me persuade you. Now, public law rules have historically been made and modified by custom. That's my thesis for today. And I say this is nothing new. But just as significantly, I would argue here that advantages accrue for those legal systems which do allow public law norms to mutate in response to the need of their polities, irrespective of constitutional or administrative law impediments. In other words, bottom-up lawmaking for public norms based on the consistent experience and acquiescence of participants in a legal system is an appropriate mechanism for change. Now, to explore these propositions, I'm going to look at 3 examples, if time permits. And these examples are as varied as the common law of property in Oregon, family law in South Africa, and separation of powers principles in the United States constitutional law. So let me first start talking about Oregon beach access and property rights. All right, to talk about property rights and beach access. First thing you've got to know is that the Fifth Amendment to our Constitution has a provision that says that nor shall private property be taken for public use without just compensation. This is sometimes known as the Takings Clause, and this provision of the Constitution was elaborated in a 1992 decision known as Lucas versus South Carolina Coastal Council. Let me disclose that I was counsel for Mr. Lucas before the Supreme Court in that case. The court, in rendering its decision, wrote this: where the state seeks to sustain regulation that deprives land of all economically beneficial use, we think it may resist compensation only if the logically antecedent inquiry, still don't know necessarily what that means, by the way, so don't be upset if you don't understand that. Only if the logically antecedent inquiry into the nature of the owner's estate shows that the prescribed use interests were not part of his title to begin with. A state must identify background principles of nuisance and property law that prohibit the landowner's uses. Okay, that's a lot to unravel. Let me try to do so simply. And that is, if the public has some kind of right over your property, sometimes we call it an easement or a servitude, and that easement or servitude is created by custom of presumably long-standing character, but that custom is only recognized by a court much more recently, has it become part of the state's background principles of property law? In other words, the paradox here is that if the custom has merged with these background principles, a property owner, when they buy their property, should know that they never had the right to build their land in a way that interfered with the public's rights. In short, when the state tells the landowner that, the state takes nothing when it regulates consistent with the custom. But if the custom only adheres at the time it's first positively recognized in the public law through a judicial precedent or a statute, then you might think that the owner's right to build had already vested, and they should be entitled to just compensation if the state purports to later bar improvement of their property. Okay, so what does all this mean? The problem here is, what do we mean when we say a custom has developed? When did that happen? Does it require a court or a legislature to confirm that? Or is it enough that it just happened? Now, In Oregon, there's almost a puzzle within a puzzle, if we could tolerate that. So let's go to Oregon to solve it. Oregon courts have been wrestling with this puzzle since 1969. In 1969, the Oregon Supreme Court handed down a decision in a case called Thornton versus Hay. And what Thornton versus Hay did was announce for the entirety of the beaches in Oregon a rule that the public customarily has the right to go onto the beach, to use it, and the landowner who's there can't say no. And the main reliance that the Oregon Supreme Court in Thornton versus Hay had was the text of Blackstone, who is the famous legal writer in late 18th century England. And his 1765 treatise is still used today. And in it, he laid out a series of conditions in which a local custom can be proven and used as a source of law. I won't bore you with the 7 or 8 different elements of what a Blackstonian local custom is. But what I will say is that Oregon courts did something strange in the Thornton versus Hay case. What they did was to declare that the rule of custom would no longer be localized. You didn't have to prove it for a particular beach. In fact, what the Oregon Supreme Court said in Thornton versus Hay was that this new rule of a customary easement now applied to every beach in the state of Oregon. And the Oregon Supreme Court added this comment to its decision. They said, because so much of our law is the product of legislation, we sometimes lose sight of the importance of custom as a source of law in our society. It seems particularly appropriate here to look at the ancient and accepted custom in this state as the source of a rule of law. The rule in this case, based upon custom, is salutary in confirming a public right. And at the same time, it takes from no man anything which he has had a legitimate reason to regard as exclusively his. All right, so what I think the court is saying here is that they understand there's a problem. They understand that in delocalizing Blackstone's customary rule, they are changing the law. And so anyone who had bought beach property before 1969 is getting a raw deal, because before 1969, they bought beach property in Oregon on the assumption that there was no customary servitude or easement. But after 1969, with this decision, there is. Now, this has led to a challenge of what's called judicial takings. When judges change a fundamental aspect of the common law, in this case, the local character of custom, isn't that a taking of property? In other words, the legislature can take property when they exercise eminent domain. Can judges do the same thing? All right, so this has spawned quite a big bit of jurisprudence that's gone to the Supreme Court at least twice, once in a case that I handled that didn't get very far, I'll be the first to admit, where Justices Scalia and O'Connor had a few words to say about custom in this context. And they were quite skeptical that Oregon courts could accomplish what they wanted to in this way. More recently, in a case called Stop the Beach Renourishment, case out of Florida, even though the Supreme Court was not dealing with an issue of custom, it made clear, at least in a plurality of the justices, which means 4 or less, so it's not really binding as you would have with a decision with 5 justices, but plurality appeared to endorse the doctrine of judicial takings. But what I want you to keep in mind, and make no mistake, Oregon courts have clearly allowed a customary regime, the rights of an indefinite public to beach access, to modify a public law rule, and that's the constitutionally entrenched rights of property owners to exclude others from their land. So here in this example, the first that I'm offering you, from property law and public law, we have an example of this tension. Now, one thing that's clear is custom is a cheap and easy solution to the nagging problem of public rights in private property. Custom is ancient. Custom extols community. Custom makes us feel good. What could possibly be wrong with a doctrine like this? And one would have to be a bit of a boor not to feel some favor for a doctrine that allows the rustic villagers to dance around the maypole on the manor lawn. And in fact, if you look at the cover of the softbound version of my book, the illustration I decided on, and thankfully the publisher agreed with me, is Peter Bruegel the Elder's dance around the maypole, which I thought was a wonderful symbol of this kind of example of custom. So again, custom makes possible villagers dancing around the maypole. It permits hardy fishermen to dry their nets on the shore, as they have done from time immemorial. And yes, custom is what gives you and your loved one the right to take a midnight stroll on a windswept beach. Something I think we've all enjoyed. All this, one might suppose, is precisely the evil of custom. Custom can be a blunt instrument against the property rights of the minority, a sharp sanction against economic holdouts and political dissidents. So that's my first example, drawn from property law in Oregon. My next example deals with family law in South Africa. The Oregon example shows you one dynamic here, and that is a customary norm is being used to advance a public good even in the face of a possible constitutional objection. South Africa and its experience with custom and family law shows you a different dimension, and that is the role of codification. When custom is crystallized, a bit like a bug frozen in amber. When it's crystallized, how well does that work to advance public law values? Now, in South Africa has had a long tradition of working with customary law of indigenous peoples in the country, and has built up a lot of experience with matters like how do you prove custom? By statute today in South Africa, a customary norm is subject to judicial notice, provided that such law can be ascertained readily and with sufficient certainty. It can also be proven by competent evidence. So sometimes litigants bring in ethnographers, local elders, chiefs, and sometimes rely on their own testimony to prove the existence of a custom. But what do you do when a custom conflicts with the public law? As I hope is clear from my discussion, not all customs are good. Some of them are downright evil. So what do you do when a custom is in conflict with a deeply held value of the public law? South Africa, like many former British colonies, has a doctrine called repugnancy, which basically asks, is the custom so outrageous, so abhorrent, so immoral, as not to be applied? Well, interestingly, very few customs in South Africa have flunked this test. What I'd like to look at is one particular codification in South African law dealing with family law. And this is known as the 1998 Recognition of Customary Marriages Act. It doesn't have a very nice acronym, I'm afraid. So let's just call it the Recognition Act. Okay, so you know what I'm talking about, and my tongue doesn't get tied up with a nasty acronym. The Recognition Act covers most substantive provisions dealing with the formalities, requirements, and consequences of customary marriage. It allows for regulation by the South African Minister of Justice. It does not purport to cover every aspect of customary marriages. So it kind of is a framework statute that generally gives courts, and most importantly, people entering into a customary marriage, a good bit of freedom. Let's see how this plays out. In African customary family law, a traditional aspect of marriage has been the payment of what's called bride wealth. It's the transfer by the groom or his family to the wife's family of an amount of wealth, usually expressed in livestock, reflecting the reproductive capacity of a woman, the bride, over her lifetime. For some scholars, bride price really reflects the value of male children born to a marriage and represents an interfamilial transfer of wealth. In South Africa, the marriage practice of bride price, which is known by the terms lobolo, ravoro, or bogadi, has been recognized in the Recognition Act as a non-repugnant custom. In other words, the statutory codification has made clear that this practice is okay, it's not repugnant. When marriages are contracted only upon partial payment of bride price, with the rest to be paid over time, South African courts have enforced these subsequent payments by effectuating customary remedies of dissolution of the marriage or forced return of the wife and her children. So here we have an example of a customary norm very much against public law values by breaking up marriages. And it doesn't take much imagination to realize that disputes about payment of bride price are involved with many divorce actions. And the amount of a refund will often depend on the number of children produced from the marriage, the more procreation of male children, the less the refund, and the conduct of parties in the marriage. The less credible the conduct of the wife, the greater the refund. Now, again, it does not take much of imagination to realize enforcement of this custom, even if it does not rise to the characterization of something completely evil or immoral, it does discriminate very much against women in all stages of their lives. Whether as girls about to enter into matrimony, as wives managing a family property regime, or as widows after the loss of a husband. And while bride price institutions have generally evaded challenge under the new constitutional or human rights standards of general equality, these rules have not. Now, what's interesting is that there's a very definite conflict here between the public law values of the South African Constitution and these marriage customs. So, for example, the South African Constitution of 1996 enshrined a right of culture, which has been generally construed to extend to claims existing under customary law. And according to the South African Constitution, these rights may not be exercised in any manner inconsistent with any other provision of the Bill of Rights. And as has been noted by the South Africa Constitutional Court, customary law should be accommodated, not merely tolerated, as part of South Africa law, provided the particular rules or provisions are not in conflict with the Constitution. But that leaves perhaps the greatest conflict of all in South Africa. The thorniest issue of a conflict between customary family law and public law is the problem of polygamy. Or, to be more accurate in South Africa, polygyny, because it really only does involve husbands having multiple wives, not the other way around. And polygyny has been a consistent feature of most family law regimes in South Africa. In Southern Africa, the custom has been to give legal effect to polygamous marriages and to create distinctive household units called houses within a larger family. And a husband is obliged to treat all his spouses with equal respect due to their rank. And in South Africa, polygyny remains a robust institution, especially with male migrant workers having simultaneously both a rural and urban spouse. Now, work by a number of South African legal institutions, including the South Africa Law Commission and other groups, have declared, and the 1998 Recognition Act has confirmed, that polygamous marriages are not, repeat, not repugnant to the common law, and they are permissible under the Constitution. The Recognition Act sets forth a principle that any pre-existing polygamous marriage is accepted, and any subsequent polygamous marriage has to have a court order approving the property relationships for all the wives and houses involved. So essentially, polygamy can continue in South Africa if a judge of appropriate jurisdiction signs off on it. If the wives' property rights cannot be safeguarded, the court can refuse to allow the subsequent polygamous marriage. So in South Africa, we have a full range of contemporary legal responses to traditional custom. We have accommodation and transformation, codification and precedent. Far from withering away, customary family law regimes and institutions appear to be thriving, and customary law will remain an essential source for substantive rules of marriage, divorce, child custody, succession, and traditional governance. Custom has resisted what would otherwise be strong impulses towards codification and harmonization of essential rules of family status, relationships, and transactions. So even in a legal domain as freighted with public law and even constitutional dimensions as family law, in those cultures where customary regimes have taken root, they are likely still to flourish. Let me go on and briefly, in the time I have allowed for me, to say a few words about U.S. constitutional law and separation of powers. Excuse me. Constitutional law would seem to be the most public of domestic public law topics. Indeed, the entire notion that a country's fundamental law would be the ultimate example of a legal domain that should be unaffected by custom. Yet, even in the case of constitutional law, customary regimes can survive and flourish. Let me give one example from U.S. constitutional law, and that is, over time, the branches of government can work out accommodations to separation of powers disputes and come up with practical solutions. If these practical solutions are of long-standing, wide consistency, and of wide acceptance by the other branches, isn't that a custom? And if that's a custom, can it not over time become binding in a constitutional system? And the U.S. Supreme Court's jurisprudence discusses a great deal about the practical exposition or practical construction of powers granted under the Constitution. And this idea goes back as far as the 1803 case of Stewart versus Laird, where the issue was Supreme Court justices riding circuit, which was something they despised doing. It was that they would get on their horse, ride to the far corners of the country, and sit in court and do this for 7 or 8 months out of the year. They did not like this at all. But nevertheless, they held in Stewart that after just a few years of practice and acquiescence, this had essentially become a constitutional custom, and they had to accept it until Congress changed the rule. Now, one of the problems with, there are really two problems as I see it, for the customary role in separation of powers disputes. One is the rule appears to be asymmetric, and that's just fancy talk for saying that it seems to ratchet in only one direction, and that's in favor of the executive branch, in favor of the presidency. Customs that have favored Congress have been more often struck down. Two examples here. The case of Fairbank versus the United States in 1901 was a case about a stamp tax on exports. Well, the Constitution says very clearly that there will be no restrictions on exports. So this would seem to be a clear violation of the constitutional text. But yet, over 150 years, at least 100 years, Congress had been passing statutes like this. In any event, the court in Fairbank struck it down and said that the idea of constitutional custom should be used only in cases of doubt. And when the constitutional text is as clear as it was in that case, there was no doubt. The second example is the case of the INS versus Chadha in 1983. This had to do with the legislative veto. My good friend Elliot Levitas, who was a member of Congress at this time and a great friend of this law school, was instrumental in developing the thinking around the legislative veto. But the legislative veto has its own problem, and that is it seems to violate another provision of the Constitution. But there's a long history from 1913 of over 200 statutes containing a legislative veto. And just to be clear here, a legislative veto says that even after the president signs a bill into law, Congress can kind of micromanage, and certain kinds of issues could go back to a congressional committee, and the committee can essentially overrule an executive branch enforcement decision. The problem in Chadha was that every president from Woodrow Wilson to Ronald Reagan, even though they signed bills that contained legislative veto provisions, still objected to them. All right, so the second issue here is what makes a constitutional custom? Well, the easy part, I think, is what I call the objective element, which is proving the duration and extent and consistency of the custom. Think back to Howard Roof. Or to put it in the words of Justice Frankfurter in his concurrence in Youngstown Steel in 1952, is the practice systemic, unbroken, long pursued? And in some cases, the Supreme Court has said so. So in Dames and Moore versus Regan in 1981, the executive branch practice of allowing for settlement of international claims was dated back to President Washington. Pretty good proof. But in other cases, the custom could not be proved. The second element, what might be called the subjective element, is did the opposing branch acquiesce in the practice? If they really did agree without objection, then it might be considered that this constitutional custom is valid. So again, as Justice Frankfurter said at Youngstown Steel, has the custom been long pursued with the knowledge of Congress? So this gets into tricky questions about what level of knowledge did the opposing branch have? What did they know and when did they know it? And there have been a number of cases that have explored precisely this issue. And I'm not sure we've entirely reached consensus on this. This remains a very difficult problem in U.S. constitutional law, especially in areas I'm interested in, like the president's war-making powers and treaty authority. But I don't worry so much about the contours of this doctrine because, again, as Justice Frankfurter warned, a practice cannot supplant a clear constitutional requirement. And he also said that illegality cannot attain legitimacy through practice. So there seem to be some built-in protections. But again, there are enough examples where custom has trumped a public law value in the form of a constitutional provision. Enough examples to make one pause and realize that custom can have a special force. So let me tie up here and try to solve this puzzle. The three examples of custom and public law that I've discussed here were chosen with great care for this lecture. Each confirms that the usages and practices of communities, whether it's the beach-going public in Oregon, tribal groups in South Africa, or the coordinate branches of the U.S. federal government, can make a custom in the face of a substantial public law restraint. In the instance of property rights in Oregon and separation of powers dispute, the constraint is nothing less than the United States Constitution itself, whether in its structural aspects or its rights-granting features. In South Africa, we have this additional statutory overlay with the Recognition Act, working in tandem with the South Africa Constitution. And I don't want you to leave here without realizing, that the illustrations of custom I've discussed today all come with substantial controversy. We may well legitimately disagree whether certain customs are even desirable. Open beach access sounds like a great idea unless you're the beach owner with hordes of people on your part of the beach. Viewed with perhaps jaundiced North American eyes and values, we might question whether South African family law customs of bride price and polygamy are terribly discriminatory against women. And even the structural constitutional proposition that the balance of power between the branches of the federal government can be modified over time by a consistent set of practices actually acquiesced in by the other branches may sound like heresy to some. And yet, despite these serious objections, these customs are, as a matter of public law design, and they have persisted. Oregon's common law doctrine of custom has not been found to be an unconstitutional judicial taking. The bolo, bride price, is still routinely paid as a condition for contracting marriages in South Africa. And the institution of polygamous marriages is alive and well in that country. U.S. courts, in making separation of powers determinations, will often have recourse to the historic practice of the political branches and will validate such usages unless they are plainly contrary to the constitutional text or unsupported by the other branches. In each of these cases, a customary regime has stood its ground against a significant public law value and managed to change it. And according to legal theory orthodoxy, as reflected in the writers mentioned here, Blackstone, Carter, Pluckett, and Hart, this is just not supposed to happen. But it has. Custom has managed to overcome its relatively weak status as a source of law. Custom has even been able to penetrate that great jurisprudential citadel of public law. And even constitutions, statutes, and administrative regulations are not immune from cross-reading and analysis in light of the usages and practices of relevant communities. And irrespective of what we might think about the merits of the underlying practice that may be a controversy, I believe it is desirable that the public law can bow in the face of custom. As a matter of design for legal systems, custom, like the original conception of a judge-made common law, allows for flexibility in a legal system. Bottom-up lawmaking may introduce some uncertainties into a legal system, and on occasion, a serious lack of uniformity, but such can always be compensated for by fervor legislative action. In any event, custom as an expression of legal will by communities can play an important role in sustaining democratic and pluralistic values in a legal system. And while the public law is a repository for such values, it is often by implementation of a community's expectation through custom that they are truly and lastingly achieved. Thank you very much.
Well, David, as is your custom, you have given us a characteristically original and luminous treatment of a very important issue. I think we now have a few minutes for questions. If members of the audience would like to come to the microphones to ask any questions they might have. And while people are coming to the microphone, David, maybe I could just start us off with one question about the intersection of custom and constitutional law, and how we might feel about the role of custom and perhaps deviating from constitutional text. You know, another area of constitutional law besides separation of powers would be, say, church and state issues. And we see there may be doctrines in constitutional law about no establishment of religion now made applicable to the states, and we see practices such as beginning legislative or even judicial proceedings with invocations of the deity. These are sometimes justified by terms like ceremonial deism or things like that. So should we view these as laudatory reflections of the influence on custom on law, or how does custom then come into play when we see some popular values perhaps intersect with elite notions of what might go on in these church-state areas?
Well, I'm certainly not as familiar on questions of church-state relations as our brother and colleague John Whitty. I would say that sometimes custom and longstanding practice, which almost bleeds off into some inquiries into originalism, what was the practice of the framers, which is a different inquiry, I think, than the customary constitutionalism that I've been talking about today. So I think it could be a marginal influence. As for the difference between elite and popular values, I think it's harder to pin down in terms of religious experience, whether religious values are inherently defined as popular values. I'm not sure if that's an easy characterization to make. So I think with some qualification, I'd say yes, there's some elements of custom that feed into this, but perhaps not as extensively as your question might suppose.
Questions?
David, Tom Remington from the Political Science Department. Thank you for a wonderful lecture. Let me push you a little bit on the constitutional relations that you cited as the third area of customary practices. You suggested at the outset that custom should be defined as practices that bubble up from below, as it were, from communities of people who have established habitual relations. But the constitutional relations strike me as being, as Robert was just suggesting, elite level, often deliberate, indeed strategic. If a president signs a bill but issues a signing statement with a view to reserving power for the future, or an executive order, the constitutionality of which he's not completely sure, I'm not sure we can properly call those customary. Those are part of the informal practices reflecting the give and take of separation of powers. So is it helpful for us to group those with customary law in the sense of family law or ordinary usage?
All right, that's a fair point, but my third example may be flawed insofar as the maker of the practice are elite institutions, whether it's the courts, a legislature, or an executive branch. I may still persist in assimilating that example to the others, in as much as it is based in practice, in history. And to the extent that it is, that it's looking at often spontaneous, practical solutions to what the political participants at the time viewed as a problem. So it's an elite source, but done out of exigency, done out of experience. I think that may move it more towards the basis of the other examples I gave.
David, I guess I'd just like to maybe push you a little bit back in the other direction in the area of property law.
That's fine.
Okay. And I guess I'm thinking about Bruce Ackerman's writings about sort of takings turning more on public expectations about what property should be protected as opposed to what a lot of theoreticians and lawyers might think should be protected. So in that sense, if you believe that, a lot of takings law is sort of turning on custom to begin with. So then the Oregon situation is almost sort of balancing the custom of, let's say, the landowners against the custom of those who would like to be on the beach. And so it's just sort of a question of where law ends and custom begins in this area.
Well, certainly. I mean, there are many more people who are solicitous towards public rights and property, and therefore may regard my discussion today on that point as quaint, because they don't even get to that point of analysis, because their view is public beach access is a natural law right, almost, and nothing should stop it. And to the extent that custom makes sense as an antidote to the tricky technical arguments by beach owners, fine, go with it. It's just my concern when I looked at this area of property law and its intersection with custom is the extent to which advocates of that position were willing to go in distorting the underlying law of custom, which was disturbing. I mean, Blackstone was a pretty smart cookie as far as I'm concerned. And to essentially parrot his formulation, but then say, oh, and by the way, all of this will apply to every beach in the state, and the analysis won't be confined to a particular community or beach, was quite disruptive, I think, of that common law doctrine.
I have time for one more question, Judge.
Yeah, I was wondering whether you thought the concept of duestitude, that laws become dead letter, do you view that as an organic part of customary law or like a separate concept?
Sorry, Judge Perot, I didn't hear the
Laws
middle part.
becoming dead letter, you know, like the laws against adultery, the laws, you know, I mean, there are all sorts of laws in family law that died out a long time ago through custom and practice. Do you consider that an inherent part of the custom, or do you consider that like a different phenomenon?
I think custom and what fancy talk would say is desuetude, when statutes cease to be effective, and many of these family law doctrines are not just in judicial precedent, they're also embodied in statutes. yeah, custom can ease a statute that simply makes no sense to ease it out of existence. Now, that's very controversial. I mean, and again, subversive. The normal process we would expect is that if a legislature believed that a provision of law had no further use, it should eliminate it. Or likewise, a court of competent jurisdiction should overrule the doctrine. So relying on custom in these situations seems somewhat inappropriate, but if that's the mechanism that's of choice, there are some examples which time did not allow me to elucidate, but that has occurred.
Wonderful. Thanks very much for that, David. Just 3 closing comments I want to make. First, I'd like to acknowledge and thank some representatives of the university who are here, our Provost Earl Lewis and Vice President Gary Hawk. And I really like to say it's really on behalf of David's friends, colleagues, and admirers, I'd like to present to you, on behalf of Emory Law School, the David Bederman Lectureship, which will now be a permanent addition to the intellectual life of Emory University, a new shining star in the galaxy of Emory's life, and I don't think any star will shine brighter than the lecture we've had today. Second, I'd like to thank all of you for being here, and after this there'll be a reception and a book signing, a chance for you to have David sign his book in the Hunter Atrium. And third, last but of course not least, I would like to thank David for giving this wonderful inauguration of the David Bederman Lectureship. Thank you, David.
Thank you.